So let's see the next questions. Next questions came in 2021. Question says, with reference to India, consider the following statement. So the two statement given, the first statement says, where the prisoner makes out a sufficient case, parole cannot be denied to such prisoners because it becomes a matter of his or right. Second says, state government have their own prisoners release on payroll rule. So second is true, as we have seen in the previous question, that the prison state has been empowered to regulate their own rules and regulation related to prisons. So the second is true, that the state government has their own prisoners release on payroll rule. Now if we talk about the first statement, so to answer the first, you need a quite extra knowledge related to payroll, what is furlough, and what is bail. So this payroll becomes, it cannot say that it cannot be denied to such prisoners because it becomes a matter of right. No, it is not a matter of right. It is a discretionary to the court. So payroll is not a matter of right. So on the basis of this, is not a matter of right. It's a discretionary of court. So the first statement is incorrect. So the answer to this question is only 2. Now if you see the explanations to these questions, so the two term, one is furlough and the another is payroll. So what is furlough? Furlough is a temporary release from prison for a specific purpose, such as attending a family funeral or visiting a sick family members. Furloughs are typically granted for a short period of time and the inmate must return to prison at the end of the furlough. The term of the furlough are set by the prison administrations. The prison administration may consider the following factors while granting a furlough. So the reason for furlough is furlough request, the inmate's behavior in prison. So this is the first conditions on which the furlough is granted, why the furlough has been requested. Second, the inmate's behavior in the prison, the behavior of the prisoner, the inmate risk of escaping. Now, whether the person who has been granted furlough can escape or not. If there is low risk of escaping, then furlough will be given. If the inmate violates the term of their furlough, they may be punished, including being denied furlough for future furlough. So if they denied, if they suppose they escape, so in this case they will be punished for the escaping, and also in future they will be denied the furlough. So this is furlough, that is a short period of leave or granted for a short period of time for any specific purpose. But payroll is a conditional release. It is a conditional release granted to an inmate who has served a portion of their prison sentence. It is a reward for good behavior and a way to reintegrate the inmate into society. Parolees are typically subject to supervisions and must adhere to certain conditions such as reporting to parole officer, staying within a certain geographical areas, and refraining from criminal activities. Parole is not an absolute right of the prisoner. Parole is a discretionary. Clear? So this is, parole is not an absolute, rather it is a discretionary. So on this basis, the first is incorrect. The parole rules are laid down by individual state government and vary from one state to another, allowing flexibility in handling parole cases based on local needs and situations. These rule includes the process for applying for parole, eligibility criteria, conditions, and the procedure for approval and monitoring of parole. So each state government has their own rule regarding the payrolls through which the prisoners are released. So on this basis, we can say the second statement is correct statement. Clear? Now if you move to the next question. So next question was asked in 2021, which is that, let's see the question, that with reference to Indian judiciary, consider the following statement. So the two statement given, the first is that any retired judge of a Supreme Court of India can be called back to sit by Chief Justice of India with prior permission of President of India. Second says a High Court in India has the power to review its own judgment as the Supreme Court does. So two statement out of the two, the first statement is correct, which means that according to Article 128, which says that Supreme Court can call back the retired judge of Supreme Court, and when he can call back, when he thinks that Supreme Court says that quorum, lack of quorum or the piling of a cases. So in this case, he will call the retired judge of the Supreme Court to be a judge, temporary judge for the time being, and that has to be done on the basis of permissions of president. So this is true. The first is true. Now the second, that a high court in India has the power to review its own judgment as the Supreme Court does. So no, it is incorrect. So this is not explicitly mentioned as mentioned related to Supreme Court. So this is a wrong statement. So answer to this question, if you see, is only one is true. The correct statement is only one, that is first is true. Now if you see the explanations related to these questions, so according to Article 28, which talks about attendance of retired judge at a sitting of a Supreme Court. So a retired judge of a Supreme Court can be requested to sit and act as a judge of the Supreme Court. The Chief Justice of India must obtain a prior approval from the President of India before requesting a retired judge to serve. The retired judge must, it is compulsory, right, give their consent before taking on the role. The retired judge while serving has the same power, privilege and jurisdictions as a regular judge of a Supreme Court. However, they are not considered a full-time judge for salaries or seniorities purpose, right? Only for the timing they will become. Now, this accordingly, this is a true statement. Now, if you see the explanation for the second statement, so according to Article 215 of the Constitutions, the High Court to be a court of record. So every High Court shall be a court of record and shall have all the power of such court, including the power to punish for the contempt of court. So there is no specific article related to the High Court power to review its own judgment, as the Supreme Court does. So according to Article 137, which says that the Supreme Court has a power to review its own judgment. So this has been mentioned under the Constitution, that Supreme Court can review its own judgment. Is it clear? So this, accordingly, the second statement becomes incorrect, and the correct answer to this is only one, that is first is true. Clear? Now if we move to the next question. So the next question was asked in 2019, and it is with the fourth statement, and we need to find the correct answer. So let's analyze all the four statement. So the motion to impeach a judge of a Supreme Court of India cannot be rejected by Supreme Speaker of the Lok Sabha as per Judicial Inquiry Act 1968. So this is this statement talks about giving an absolute restrictions on the Speaker. This is not correct, because Speaker says that if the Speaker finds the motions, that is removal motions, then he can allow the leave to introduce the motion. So this is the first statement is incorrect. So this A cannot be answer and D cannot be the answer. Now if you see the B and C, so B and C, in which the 3 is common, so it means the second is also incorrect, because we are left with the only two options, B and C. The 3 is there, it isn't compulsory that it has to be answer, right? Now let's be why the second is incorrect. So the Constitution of India defines and gives detail of what constitute incapacity and proved misbehavior of the judges of Supreme Court. No, it is incorrect. So the Constitution of India does not define the term incapacity and proved misbehavior, and these two are the ground on which the judges of Supreme Court can removed. But the Constitution does not define what does the incapacity or proved misbehavior means. So second is also incorrect, right? So now we are left with the third and fourth. The third is correct according to options we have. So third says the detail of the process of impeachment of a judges of Supreme Court of India are given in 4 Judges Inquiry Act 1968. Yes, it is true, because it is, if you have no knowledge about the third also, then also through elimination method you can, there is no need to analyze this because it is already been in the option, so it has to be correct. Now need to only check the fourth options whether the fourth is correct or not. So it says that if the motion for impeachment of a judge is taken up for voting, the law requires that motion to be backed by each house of the parliament and supported by a majority of total membership of that house and not less than 2/3 of the total members of that house present and voting, that is through the special majority. Yes, and special majority. So each house separately has to pass the motion through special majority. That it means, it also says that this does not require to be done in joint sitting. Clear? So joint sitting is not allowed, or the house cannot pass the impeachment motions or removal motion of judges of the Supreme Court or High Court on the basis of joint sitting. Rather, the each house separately has to pass with a special majority. Yes, the fourth is correct. So our answer to this question becomes an C, that is 3 and 4 only are correct statement. Clear? So this, the fourth option has been correct through the Article 124. So according to Article 124, which talks about the majority required for removal of Supreme Court judges. Clear? Now if you see the explanations to the given questions, so to explanations, the Judges Inquiry Act 1968 provides the procedure for investigations and removal of judges of Supreme Court and High Court judges in India for misbehavior or incapacity, as laid out in Article 124 Clause 4 and Article 217 Clause 1 Subclause B. This is related to High Court judges and this is related to Supreme Court judges of Indian constitutions. So ground for removal according to Inquiry Act, a judge can be removed on the ground of proved misbehavior and incapacity not been defined. So the removal process applies to judges of Supreme Court and High Court. How to initiation of removal process? A motion for removal must be introduced in either House of Parliament. If it is to be introduced in Lok Sabha, then 100 members of the Lok Sabha must sign the motions, and the motion is to be addressed to President, and delivered to the presiding officer of the House. So it has, if the motion is to be introduced in the Lok Sabha, then 100 member has to sign the motion which is addressed to the President and it is to be given to Speaker. Now if the Rajya Sabha wants, if the members of Rajya Sabha wants to remove, then at least 50 members, the minimum 50 members has to sign the motion which is addressed to President and given to the Chairman of the Rajya Sabha. Clear? Now constitutions of an inquiry committee. So once the motion is admitted, right? So what the procedure says, that the motions, if suppose that motions of removal motions of judges is been introduced in one house, So other house will conduct an inquiry. Other house will conduct inquiry by itself or through committee. Right? So the house in which the motion is introduced will not conduct an inquiry. The inquiry will be done by the another house in which the motion is not introduced. Either they can be done by their own or through a committee. So it says that when motion is admitted, the speaker or the chairman form a three-member inquiry committee as the case may be. So if the motion is introduced in the Lok Sabha, then the chairman will constitute a three-member committee, or if the motion is introduced in Rajya Sabha, then a speaker will constitute a three-member committee in which includes a judge of a Supreme Court, a chief justice of High Court, and a distinguished jurist. So they will inquiry the will be a part of in committee, and they will inquiry about the allegation, that is proved misbehavior and incapacity. And if this committee investigate, if this committee finds the charged proven that the charge is true, that is either the judge is incapable or it has behaved misbehavior, then along with the report, the motion will submitted to the house. Which house? Where the bill is pending, in means where the bill has been introduced. Clear? So the committee investigate the allegation against the judges. Now the committee examine evidence and gave the judge an opportunity to defend themselves. After inquiry, the committee submitted its report to Parliament to the House, where the motion is introduced. Motion introduced. Clear? Now then the Parliament with a special majority approved. If the committee finds the judge guilty, both House of Parliament must pass the motions by special majority. That is majority of 2/3 of members present and voting in each house plus total membership of the house. Majority of total membership of the house. Right? Once each house has passed this motions with the required majority, then the motion will be sent to the president for its assent. And once the president issued an order to removal from the office. So if the president signed the motions, then the judge will be removed from his office. Clear? So this is the procedure and conditions mentioned under Judges Inquiry Act 1968. So Judges Inquiry Act 1968 does not prevent the speaker from rejecting an impeachment motion at an admission level. So it does not empower the speaker that they have a they cannot reject or they cannot send the back. It is up to the speaker or presiding officer basically. If they find that motion is incorrect, then they can allow the introductions or they give the leave of the house. Is it clear? So this is now if you see the next explanations to the second. So on this basis we can say that first is incorrect, right, and the third is correct, which is given by this, right. Now if you see the next explanations which is given according to Article 124 clause 4 says a judge of a Supreme Court shall not be removed from his office except by an order of President passed after an address by each House of Parliament supported by a majority of total membership of that House and by a majority of not less than 2/3 of the members of the House present and voting has been presented to the President in the same sessions for such removals on the ground of proved misbehavior and incapacity. Clear? So Constitution does not define or provide details on what exactly constitute incapacity or proved misbehavior. So according to Article 124 clause 4, the second is incorrect and the fourth is correct statement. Is it clear? Okay. So this is an explanations to this question number 8. Now if you move to the next questions. So next question was asked in 2019. So the question says that with reference to the Constitution of India, prohibitions or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional power under Article 142. So it could mean which of the following, right? So basically this related to us, the question asking from you that 142 empowers which of the organizations of Indian government or under the constitutions. So if you see the article, if you remember an overall article, so 142 article is somehow somewhere related to the power of Supreme Court. So the options, if the options is were somehow related to Supreme Court, that will be our answer. Okay. Now, if we analyze the first options, so it says the decision taken by the election commissions of India. So, Election Commission of India, article start from article 324. So, this cannot be our answer on the basis of this article. Clear? So, A cannot be the answer. Next, the Supreme Court of India is not constrained in exercise of its power by the law made by Parliament. It talks about a Supreme Court. So yes, Article 124 start from the 124 related to Supreme Court. So yes, it can be our answer. Next, move to the third options. So in the event of grave financial crisis in country, the President of India can declare financial emergency without the consult from the cabinet. So this is incorrect on two grounds. First, that financial emergency is given under Articles 360, not related to 142. And on the second ground, that without the consult of from cabinet. So President cannot impose financial emergency without consult of cabinet. So that has to be done on the after consultations of the cabinet. So on this two ground, it is incorrect. Clear? So this is from Article 360. Now, if you see, the state legislature cannot make laws on a certain matters without the concurrence of the union legislature. It means this is related to the 7th schedule, that is a list of this, right, or a legislative power. So this is also cannot be the answer. So we are left with only one option, that is B. So on the knowledge background, logical, we can say that answer to this question is B, because the article which talks about, that is 142, is somehow related to the Supreme Court of India. If overall, if we have an idea that which articles talking about which of the followings. Clear? Okay. So let's see the explanations to this questions. Let's see explanations. So according to Article 142, Clause 1 states that the Supreme Court has the power to pass any decree or order necessary for doing complete justice in any matter pending before it. This means that the Supreme Court can override ordinary laws if necessary to ensure complete justice. Okay. This article provides extraordinary power to Supreme Court, which are not limited by any existing law made by the Parliament. So basically, it means it trying to say that by using article under Supreme Court under Article 142, it can void the parliamentary law to impose a decree or order of the Supreme Court if it is necessary to do the complete justice. Is it clear? So this is 42. Now, if is next, see, the Article 142 allows the Supreme Court to act beyond the limitation of ordinary law. That is, it is acting beyond the ordinary law. So ordinary law cannot be act as an limitations on the power of Supreme Court, which the question talks about, right? So in the case, it can override the ordinary law if necessary to ensure complete justice. Even if there is an ordinary law restricting some actions, the Supreme Court can override it using 142 if it deems necessary for justice. Like example, we can say that in Babri Masjid Ram Janmabhoomi case in 2019, the Supreme Court used Article 142 to direct the allocation of land beyond what was restricted, strictly provided in the law. So this is one of the example where the 142 has been used by the Supreme Court in Ram Janmabhoomi case. So on this explanations, we can say the second is a correct statement. Clear? Now, why the first is incorrect? So first, it's election commissions. According to Article 329, the decision of Election Commission of India can be challenged in court, especially if there is a legal or constitutional issues. Right. So this is incorrect. Why? Because Article 142 talks about the Supreme Court power, not about the election commissions, which says that decision of Election Commission of India while discharging its duties cannot be challenged. So it means it is not beyond the judicial review of the power of the court. So this is incorrect. Now next, the power of the President of India to declare a financial emergency is outlined under Article 368, that is C, and not according to Article 142. It requires the recommendations of the Council of Ministers, and the President cannot act independently of the Cabinet in this regard. So on the two reasons, the C is incorrect. Now the last says the state legislature cannot make law on certain matters without the concurrence of union legislature. Statement refers to the relationship between state and the union legislature, which governed through Article 245, 246 and 254. That is 7th schedule dealt under Article 246 of the Constitution. So on this basis, so these questions can also be simply answered through your just and knowledge background logic which you can apply that this article is somehow related to which of the subject matter. If you roughly remember this related to the roughly remember the articles relations with which of the given option subject matter. Clear? So next, let's move to the next question. So next question was asked in 2015. So the question says, who or which of the following is a custodian of Indian constitutions? So this is an easy question. So this can be answered easily that the custodian of Indian constitution is a Supreme Court of India. Clear? So it is a custodian of it is a Supreme Court of India, and how it protect, right? Why? Because Supreme Court is a final interpreter of the Constitution. Supreme Court has a judicial review power, right? So it can, through using judicial review power, it can call unconstitutional the act of legislature or the act of executive, through which it can protect the Constitution and establish the supremacy of constitutions, and it can establish the supremacy of constitutions. As we know that India having a supremacy of constitutions. Clear? So this is a direct questions and this can be answered easily. Everyone knows this answer. So Supreme Court of India is regarded as a custodian and guardian of Indian Constitution because it has the ultimate authority to interpret, protect and uphold the constitutions. This role is derived from its power of judicial review under Article 132 and 136. This is 136 is related to special leave petitions. This is special leave petitions, which allows it to strike down unconstitutional laws or executive action. So this is very simple. Everyone knows this answer. Okay?